On Wednesday night, ABC announced it was pulling Jimmy Kimmel Live off the air indefinitely after backlash over a comment Kimmel made in his monologue Monday about right-wing reaction to a 22-year-old Utah man charged with fatally shooting conservative activist Charlie Kirk.
We hit some new lows over the weekend with the MAGA gang desperately trying to characterize this kid who murdered Charlie Kirk as anything other than one of them and doing everything they can to score political points from it.
Kimmel's comments came after a weekend of rampant speculation on social media over the alleged shooter's motive and political leanings, something officials sought to clarify in a press conference Tuesday. Then Wednesday, on a podcast, FCC Chairman Brendan Carr threatened stations that carry Kimmel's program. A company called Nexstar operates 32 ABC stations and needs FCC approval for a merger, so Nexstar quickly announced it was pulling Kimmel's show. Right-wing-led Sinclair Broadcast Group followed, and ABC decided to suspend the program entirely. This all comes, of course, just 2 months after CBS announced its planned end next year of The Late Show with Stephen Colbert, another longtime Trump critic. CBS owner Paramount was also seeking and got FCC approval of a merger after that move. But it's not just late-night talk show hosts facing such pressure and backlash. The Texas Education Agency Wednesday confirmed that it's reviewing more than 280 complaints against public school teachers and staff who posted comments on social media about the shooting. Here in the Houston area, Klein ISD dismissed a social studies teacher over comments he posted about Kirk. A Goose Creek Consolidated ISD teacher also faces termination after suggesting Kirk's death was the, quote, consequences of his actions. Sarah Rolwitz told Houston Public Media she was fired from the Bilingual Education Institute for her posts criticizing public response to Kirk's death. At Texas Tech University in Lubbock, a student was arrested by campus police Friday at a memorial for Kirk after a video of her celebrating his death went viral. State lawmakers have since announced new House and Senate committees focused on civil discourse and freedom of speech in higher education. Many who have decried these actions characterize them as unconstitutional limits on free speech. Are they? Let's discuss now with Charles Rocky Rhodes, constitutional law professor at the University of Missouri School of Law, formerly with South Texas College of Law, Houston. Rocky, good morning. Can't hear you, but we'll see if we can get that worked out. And let's start with the basics here. What rights do we have when it comes to free speech guarantees, Rocky?
Well, it's going to depend quite a bit on the particular context of what kind of situation we're dealing with, whether or not this person is employed by the government, is a student, is somebody who's a private citizen, and is taking the fact that they are having adverse actions against them from a private employer. So first, we're going to have to categorize what is the relationship of the individual to the government. And it's going to depend. Your free speech rights are going to vary depending on those situations, because you went through a lot of different situations where this issue has come up, and every one of those would have to be analyzed a little bit differently. The late night talk show hosts are not working for the government. Now, on the other hand, there are strong allegations in each of these cases that the government is ultimately responsible for their termination because they were doing what's known as job owning, trying to get private employers to do their dirty work for them. And so there may be free speech claims under that doctrine. Then we have to look at student expressive rights on campuses versus public employee school rights to be able to speak outside of your job duties. And so all those have a little bit of a different analysis. It's not a one-size-fits-all situation.
That said, I think they do all have some things in common. And one thing they all have in common is that just because we have the constitutional right to say what we want within some limits doesn't mean there won't be consequences for that speech. So where is the line between those consequences being acceptable under the law and where and how do they become unacceptable?
So, I'm going to have to break this out because there's no way to just answer that all at once. So let's take the public school teachers first. The idea there is that you as a public employee do still have First Amendment rights. And you do have the right to be able to express yourself on social media as long as you're doing it as a citizen and not pursuant to your official job duties, and as long as it's on a matter of public concern. Then the issue of consequences comes up in what they call the Pickering balance, where you balance the free speech rights of the individual against the government's need to provide efficient administrative assistance through its government programs. And in those cases, you have to look at it case by case. And one of the most important cases that I think is going to be really relevant in these kinds of situations is a decision that actually came from Harris County, Rankin versus McPherson, that went all the way to the United States Supreme Court. And in that case, you had a clerical worker at the constable's office who, after President Reagan got shot, remarked to her coworker boyfriend, "If they go for him again, I hope they get him." They were talking about policies of President Reagan with respect to Black Americans. She was on a break. She was a clerical employee, but somebody else heard the comment, reported it to the constable, and she was fired. The United States Supreme Court, in a 5-4 decision, said that she had the right to make that statement, that it was on a matter of public concern. It was not part of her job duties. She was on her break. And that on balance, just the fact that she worked for the constable's office with law enforcement responsibilities, it didn't mean that she didn't have the right to be able to express her opinion that was obviously a hyperbole on the president and his policies, and therefore she was improperly fired. But obviously, if you change facts a little bit, that circumstance can change a lot. If she had been making that comment out in public, perhaps that would have denigrated the ability of the constable's office to perform its necessary function. So it's really very much a case-by-case analysis on what consequences that are going to be able to be constitutionally permissible with respect to each of these actions.
It does sound like one of the key distinctions here, because boy, does that case sound very relevant to what we're talking about and what we're seeing right now. But it seems like one of the key distinctions may be, is there a huge difference between saying that privately to another person and posting something on a social media platform? And does it matter which platform and who can have access to that comment? I can see all kinds of interesting details here that lawyers and judges will have to parse.
Exactly. And in fact, I spent a whole half a class going through, well, what happens if we change this a little bit? What's happened if we change this? Would it still come to the same result? And it was a 5-4 decision as it was, with some of the dissenters arguing that she had no right to work for the cops and cheer for the robbers. And so this is a very case-by-case analysis. And so we have to look at that with the public school teachers. Now, with respect to private citizens like Jimmy Kimmel or Stephen Colbert, that their private employers let them go or fail to renew their program or terminate their program or whatever the case may be. In those situations, we're looking to see, was the government ultimately responsible for that decision? In other words, did they indirectly do what the government could not do directly? Because the government has more control over the speech of its own public employees. So if you're working for the government, it's not that you're giving up your free speech rights, you still have them, but the government is able to more closely punish you if that speech has consequences that end up hurting your employer. Whereas with somebody like Jimmy Kimmel or Stephen Colbert, the government has no authority over them to punish them because of their speech. But if they are indirectly creating the pressure of these companies to terminate or to alter their programming, there's another doctrine and another recent relevant case that shows that the government is not allowed to do that. And that actually involved the NRA. And the New York Attorney General's office was pressuring banks not to do business with the NRA. And the Supreme Court unanimously said that that's a potential First Amendment violation if the NRA can prove that that's what happened. And so you have to look at this very much on a case-by-case basis to try to determine in which situations does the government cross that line of improperly punishing an individual for their expressive freedoms.
Does it seem clear to you if that line has been crossed when we talk about public officials publicly calling for employers to fire employees they find have been speaking out in one capacity or another about this?
Yeah, I think in some of these cases we are going to have some very good employment discrimination claims against, and especially in the situations when we're dealing with the school firings, that some of these posts do not seem to meet the level of the type of um, disruption in the office that is necessary before an employee can be terminated for their speech. So I think some of these are going to have good First Amendment claims. But again, it's going to have to be a case by case basis, a case by case analysis of exactly what happened and what the comments were and how those are or are not impacting the ability of the government to be able to provide services. And it can't just be that, well, we have an interest in everybody being on the same page and having the same reverence for Charlie Kirk's death, because that's the government is not the choice of the government to make. They have to be able to treat the ideas the same, whether they are for the ideas or against them. But it's all about the disruption that might be caused, because that's the very basis of our First Amendment is an anti-censorship, that the government ideal that the government should not be involved in censoring ideas, messages, or viewpoints, because that's for the marketplace of ideas to be able to battle that out. And so you do have a right to express yourself in the marketplace of ideas, although right now it's a scary time to do that because obviously there are being threats that you may have job and employment repercussions as a result.
Yeah, so some of these folks may very well have a good claim in court, but even if you are wrongly fired and the courts do ultimately conclude that some years down the road probably that was the case, we are talking about people's livelihoods being in jeopardy and affected, and it costs time and money to fight a legal case with no guarantee of that outcome. Is that just how it goes? Those are the consequences of speaking out as well?
Yeah, unfortunately, yes, and that's absolutely true. Even if you take my case about the deputy clerical worker in the constable's office in Rankin versus McPherson, Miss McPherson, it took her, that case was 7 or 8 years in the making before it was finally resolved by the United States Supreme Court. And in the meantime, she did get fired from her job, and eventually she got back pay and attorney's fees and full recovery, but that took years. And so that is one of the concerns, is that in the meantime, the government can use these threats as a hammer to really stifle individuals' expressive freedoms. I've heard that there are some school districts that have essentially sent out edicts that anybody talking about this is going to be fired. I mean, that is clearly unconstitutional. You may be able to fire some individuals depending on the extent to which their comments have interfered with their ability to provide efficient government services. But to say that you can't talk about this or you're going to be fired is a clear violation of First Amendment freedoms. But yet it accomplishes what sometimes I think the government wants to do, which is to just stifle the debate about this, which is exactly contrary to the very basis of our First Amendment.
Well, and that part brings us back, I guess, to the late night talk show hosts and what we've seen lately involving both Stephen Colbert and now Jimmy Kimmel. Is there any legal protection against what we've seen there, where the FCC itself specifically is threatening, in essence, to hold up corporate mergers or take some other action in the interest of getting administration critics off the air?
Yeah, and I think there is, although that's going to, require again a lawsuit to try to say that this is impermissible government jawboning, that the government is trying to do indirectly what it's not allowed to do directly, that the government has no authority over Stephen Colbert, over Jimmy Kimmel with respect to their private speech rights. Now, of course, the networks do, because they're the bosses of Jimmy Kimmel and Stephen Colbert. But to the extent that the government is pressuring the networks to do things by threatening investigations, by undertaking other actions, that those types of threats would be impermissible under the First Amendment. And like I said, this goes both ways. This was on the other side. This was recently conservatives claiming under the Biden administration that their rights on social media were being squelched. We also had, as I mentioned, the fact that during the the New York Attorney General's investigation, that it kind of did the same thing with respect to kind of pressuring organizations not to do business with the NRA. That the Supreme Court unanimously across the ideological spectrum said that that was a First Amendment claim, that if they can prove that. So if you can prove and establish these things, there are a problem. But on the other hand, as we've just been talking about, in both of these situations, the companies had mergers that they want approved. And so rather than fighting this out in court, they are essentially capitulating to be able to get their potential merger or whatever business deal that they want done that they need from the government.
And I guess they wouldn't want to fight after the fact because there's some future merger that they'd be afraid might get held up, right?
Yeah, and it's also a little bit difficult. The remedies that you would get after the fact are, especially against the federal government, are very limited. You have to jump through a lot of procedural hoops, and there may not be a pot of gold at the end of the rainbow anyway that makes it worthwhile. It's a little different when the federal government has less situations you can sue them, and without getting way into the weeds here, which I'm sure listeners at 9 o'clock in the morning don't want to get into, that there's more difficulties with suing the federal government in some situations than a state government because of the ability to have a cause of action and things like that. So you can sue the federal government for injunctive relief, equitable relief to preclude things from happening, but it's a little harder sometimes to get damage relief. You have to go to the court of claims, and there's all kinds of hoops you have to jump through.
I guess the bottom line, though, is, as your Reagan-era example would suggest, this is not necessarily a new phenomenon.
No, but as you properly suggested, it is from the standpoint of the ubiquity of social media, right? Which early in this, when these earlier cases, when these kinds of comments weren't transmitted to potentially thousands or hundreds of thousands of individuals. And so a lot of this we're seeing play out in a format in which our past cases really haven't dealt with, at least from the United States Supreme Court.
Charles Rocky Rhodes is a former Houstonian, now professor with the University of Missouri School of Law. Rocky, thanks very much.
Thank you, Craig.